CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15, Sunday afternoon at 1 o'clock. Again, it's repeated on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. If there's parents out there that need help, we talk on a one-to-one basis. They can give us a call, and we give them our experience of 20 plus years. My number here in Des Moines, Iowa is 515-276-3956, and John's number is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI, that stands for Child Protection in Iowa, and it's on these various topic areas within that broad range that we have two major tasks. One is to influence public policy as it relates to child protection issues, and secondly, we work with families, as Don mentioned a moment ago, on a one-on-one basis. We are not attorneys, so we do not hold ourselves out to be practicing law without a license. You see, there are some, however, there are some things that parents can do on their own, and it's a good idea that you be an active part of any defense that you have against the juvenile court and the Department of Human Services. Quite often the question comes, can they do that? Can they do that to me? Can they do this to me? And in some cases I have to answer them yes. Some cases I have to answer them no. Can they come and visit my child at school? Well, the law permits something called confidential access. It's a rather brutal type of law because it means that they can come and violate your Fourth Amendment rights by coming and talking to your children. And information they can get on your children, they can take back to their nest and write up a report, and not only get you involved in the juvenile court situation, the administrative arena, write up child abuse reports against you, which could affect any kind of professional work that you're doing. For instance, if you have a license as a dentist or a license as a such as in nursing and that sort of thing, or in teaching, that could affect your licensure. It could also affect even if the children just happen to mention that there's a bong pipe in mom's on mom's night table. Well, if they can come and talk to your children under confidential access, which is provided by the law for a different purpose, then what they're doing is they're violating your Fourth Amendment rights, taking information from you, violating your privacy rights under the law. And they think, I suppose they figure that because their cause is noble, then they can violate your rights. And it's amazing to me how little by little, maybe not so little anymore, but case by case, they are embarking upon an effort to completely destroy all of the rights that we have under the Constitution. So anytime you visit a military cemetery, you can say, was it all, did these brave men and women die for a cause which we cannot protect? They bought us the liberty, they bought us the freedom, they bought us the protections of the Constitution, and now we have judges and others who would like to completely annihilate those rights. And I think it's behooves us to keep heads up when they come and talk to your children at school. It would be wise to indicate in written form, and I wish I had the verbiage already prepared for you, but just to say, no one talks to my children at school unless they were part of the staff of the school. No one talks to my children without my written express consent. So, and I think they might take you seriously enough that your Fourth Amendment rights would be protected under those circumstances. Don't count on it, because they're out when they want to go out and write up reports. The school is the handiest place to go, because all of the children from in this school year gravitate toward the community school. They're hauled in by buses, and they can make a number of calls without moving from place to place. By the way, there are some restrictions on even confidential access. They must have made an attempt to contact the parents at their home before they can exercise confidential access, and they must have contacted their supervisor. Well, you might be able to nail them down on whether or not they made a visit to your home by one hook or crook, but I think it'd be very difficult for them to prove that they actually talked to a supervisor, or whether they just knew the supervisor would approve of confidential access at school. The confidential access is something that you might want to give some attention to, however, now that school is in its beginning, because this is one way in which an intrusion of a public officer into your school district could spell real trouble. And we're going to talk to a fellow that doesn't fool around with trouble. He fools around with, I shouldn't say he fools around, he does everything he can to enhance solutions. We're going to talk, we're going to have Don give you an idea, however, of another area of government that is giving us some problems, and that is something that arises from domestic abuse. If we thought that they're treating the law badly in child protection, you should see what they do with domestic abuse. Don?
Okay, thanks, John. This article says the U.S. Supreme Court recently agreed to hear another case, U.S. versus Hayes, to decide whether an old misdemeanor domestic violence conviction can bar a man from ever owning a gun. Everyone agrees that convicted felons should not have guns, but misdemeanors are minor offenses that usually carry no jail time. Under feministic pressure, most courts have interpreted federal law broadly to deprive millions of men of their gun rights. However, in the Hayes case, a 2-to-1 majority on the Fourth Circuit had the courage to stand up to the feminists and rule that Hayes had no fair warning that prosecutors would stretch the definition of domestic violence to include his minor offense. Randy Hayes had a dispute with his wife in 1994, pled guilty to misdemeanor battery, and served 1 year of probation. 10 years later, he was prosecuted for having a Winchester rifle in his West Virginia home. Why are men with clean histories, except for one domestic dispute, punished like hardened criminals who mug strangers on the street? The answer is that the feminist agenda calls for domestic violence laws to punish husbands and fathers above and beyond what can be proven in court under due process procedures. When Senator Dianne Feinstein voted for the federal law prohibiting a man from owning a gun if he has a domestic violence conviction, she stated, quote, "It is an unfortunate fact that many domestic violence offenders are never convicted of a felony. Outdated or ineffective laws often treat domestic violence as a lesser offense. Plea bargains often result in misdemeanor convictions for what are really felony crimes." In other words, Senator Feinstein wants to pretend a man is a felon, even if he is not. That's the feministic, anti-male agenda. The U.S. Supreme Court ruled this year in District of Columbia versus Heller that we all have fundamental constitutional rights to own and use a gun. We will soon see how serious the court is in defending our Second Amendment right. It's time to restore basic constitutional rights to husbands and fathers by repudiating the feministic agenda that considers men guilty unless proven innocent. John, I have a comment on that, or a side issue. We've got a woman running for sheriff here in Polk County, and I believe she would stand up for the support of people owning guns. She's talked about that she believes the citizens have a right to carry guns. That new person running for sheriff is in Polk County is Linda Ripley. John, you have a comment?
And we can't say vote for Linda, but we can say what was the comment she made about the Ripley request? Ripley for sheriff. Believe it. Okay.
And it shall come to pass in November.
Okay.
So get out and vote in November.
The same tribe has been running the courthouse for generations, it seems, and I think it would be a remarkable switch of events if we could turn the sheriff's department over to someone who is really competent. What happened is that Linda Ripley said that a police chief in Des Moines wanted the job of sheriff, and the people over in the sheriff's department says, "Come on over, we'll install you as a sheriff's deputy, and we know that the sheriff is not going to run again, and you'll be a shoo-in." So we'll have Des Moines' retired police chief now becoming Polk County's sheriff. So you might want to give some good consideration as to who you would like to run the sheriff's department. By the way, that is a very powerful department. The sheriff's department can tell the feds when and where and if they can come into the county, because the sheriff has by a constitutional design and by traditional design runs the place. So I think you want to be very careful. By the way, it seems as though to me the sheriff's department has goofed up something terrible. We learned, I think, from listening to our sheriff's candidate for the sheriff's department that the morale is extremely poor in the sheriff's department, and it needs to be straightened up. And it seems as though there are deputies all over the place. It seems as though we are inundated by more and more sheriffs. And then they build a new jail. And the new jail is supposed to save Polk County taxpayers a lot of money because they're going to um, house federal prisoners. Then they found out that the feds aren't going to pay anywhere near as much as they thought when they decided to build that new magnificent jail just north of the Interstate I-80. Now they're developing programs for the prisoners, and the money that they said was going to be saved will not be saved because they're going to spend that money on new programs. Now, when you have a stack of money that you're saving, either it goes to lower the taxes or to apply to some other place that where taxes would have to be raised in order to pay for other projects. Now they're going to spend that money twice because any money that they save, they're going to spend on these new model programs for prisoners. It's a rather interesting idea because they think they can get the prisoners out of the prison or out of the Polk County Jail, they call it, sooner. Of course, they can't affect what the feds do because the feds are the ones who say whether a person is released from incarceration. And quite often, when the feds convict a person for a crime and they put you in prison for 156 months, that means 156 months. There's no parole. So here we are trying to create programs to get them out released early when the feds have no intention of releasing their prisoners early. I think we need somebody at the helm who knows a little bit about economics, who knows how to run a jail, who knows how to run the sheriff's department, who has some sense of security, how to run security, and how best to use personnel, and how best to increase the morale of these people. I was very much impressed by the presentation given by this candidate, Linda Ripley, as she presented a tremendous proposal for running the sheriff's department.
She gave me the opinion that she would not let the feds run over top of her. As you said earlier, the sheriff's office is actually the highest office in the land, and they don't have a right to, but yet a lot of sheriffs do allow the feds to come in and control them. But then we have sheriffs across the country that do stand up against the feds, and they can't overrun our rights. John?
Okay. Well, I think at least we have an alternative to the old machine that has run the courthouse for a number of years. And you got my vote, Linda. I would like to see more people of your tenacity in there. By the way, she has observed what goes on in the jail, and she's just well treated by the prisoners there. They just love her. She's just kind of like coming home to mom, and but she does. She lets them know who's boss, obviously, and I think that we need that kind of control. I spoke a moment ago about troublemaking in the courts. There are people who fiddle-fool around with the courts and are overly critical of the courts. I'm one who looks very critically at the courts, and I applaud a judge who will very carefully look at the law and will maybe a rule against you on an objection, but then he'll tell you why he ruled on that objection, instead of saying objection overruled or whatever. Uh, so I look for the kind of person sitting on the bench who follows the law, who is careful with his demeanor before the public, who is not a tyrant in a black robe. Um, there are a lot of things, however, that corrupt the judiciary. There are a lot of things that corrupt the whole system, and I've learned in just in the last few years how the prosecutor's office is also corrupted. That can become an unelected office, even though the chief is elected. The chief prosecutor is elected. The underlings are not subjected to the scrutiny of an election. You can't throw them out because you didn't hire them. The chief attorney, county attorney, hired them, and so we have all kinds of corruption going on there, and all kinds of rules, such as immunity rules, that keep those fellows in office, even though fellows and girls, by the way, it seems as though the whole place is being overrun by the females. The judiciary has a large number of women coming into it. In fact, even our chief justice of the Iowa Supreme Court is female. And now the females seem to be overrunning the prosecutor's office. I don't know where they got the idea, but they certainly are taking over. Well, there is a gentleman who has given of himself to develop some comments from time to time, and one would think that he would like to see some reform. Here is the Director of Legal Solutions, Terrance Walker.
Well, thanks a lot, John. You always come up with something new on me, huh? I just keep it simple. The judge of the judges. Somebody's got to do it, so it might as well be me. You can't wait for the president to elect someone or appoint someone to do that. You're not not gonna get that from a legislative branch that's full of lawyers that are brainwashed on the uprightness of the legal system. And you're definitely not going to get it from the judicial branch because they really don't want a judge of the judges. So here I am, the citizen appointed judge of the judges. But I just had a couple interesting stories. I was thumbing through victimsoflaw.net, which is a really good legal site if you guys are interested in looking at things that pertain to the justice system and the judiciary and the attorneys and whatnot, the whole gamut. They have a lot of information, a lot of articles, a lot of different things from across the country that you don't normally see, not pressed forth necessarily at the top of the news, unlike the crimes and the murders and all that stuff. A lot of interesting stuff that affects us that goes on in the justice system. One of the most interesting, I thought, was regarding the appointment or the selection of a judge or a judicial candidate, I should say, for the Middle District of Tennessee. His name is Gustavus Puryear the Fourth. Now, this guy was just recently appointed to, or not appointed, but he was just recently given the nod to get nominated for a district judgeship in the Middle District of Tennessee. And interestingly enough, the same guy is a 40-year-old fella that has been a lawyer for a number of years. I think he graduated law school in '93. It looks like. Um, he has a lot of opposition that's being garnered against him, and it was actually started by one man, a guy that had been in prison actually for armed robbery. Alex Friedman, who's a 39-year-old convicted armed robber turned inmate advocate. He apparently he was incarcerated at a Corrections Corporation of America facility. Now, Corrections Corporation of America is the largest for-profit prison corporation or operation in America, and they have about 66 facilities across the country. And the way a lot of these places operate, I would equate it to the United States in-state version of Guantanamo. And the reason I say that is because whereas Guantanamo was a separate entity that was basically seen as outside the spectrum of judicial reach or any sort of legal boundaries. This is basically what Corrections Corporations of America does in conjunction with a lot of the states. Because what a lot of the states do to their inmates is they ship them to the Correction Corporation of America institution or facility, and they typically ship them out of state. Now, when they do that, they forego a lot of the state protections that the person has. So, they can't really call the state ombudsman, because the ombudsman will be like, well, we realize that you were incarcerated due to a conviction here in Iowa, but you're now in Missouri. So, therefore, we can't help you. So you have a situation whereby you have a person's rights in limbo. And this is the game that's being played nowadays with the Correction Corporation of America. But I thought it was very interesting that this guy, Alex Friedman, 39, he's about a year younger than this judicial nominee Gustavus Puryear the fourth. He even put up a website against Puryear. It's called www.againstpuryear.org. And his chief complaint is that Gustavus Puryear had been the chief counsel for Correction Corporation of America. He worked there from 2001 up until he was, I believe, nominated here this past January. And he apparently, during his time at Correction Corporation of America, he during like 2006, he was alleged to have made a salary of $238,000 or $237,000 plus $602,000 in other long-term compensation. And this is according to Forbes.com. Since 2006, he has sold shares of Correction Corporation stock valued at over $3 million. And Correction Corporation has basically made Puryear a multimillionaire. And the chief complaint in this regard is that it would be a conflict of interest for Puryear to represent the judicial branch and to be over these cases. There's some 400 cases naming Correction Corporation of America in the Middle District of Tennessee. And since 2000, 260 cases have been filed. And Mr. Friedman, who is advocating against the nomination or the appointment of this judge, is basically went through great lengths to show how there would be so many conflicts of interest because the Correction Corporation of America, their basically out of, they're headquartered in the Middle District of Tennessee. So you basically have a situation whereby you'd have a judge who had basically been made a multimillionaire from an institution, a for-profit corporation that incarcerates people, and then have all these hundreds of cases being basically tried in the same district where this guy would be. Actually, as of February 12, 2008, there were 12 cases in the Middle District pending against CCA. Either Mr. Puryear provided incorrect information to the Senate Judiciary Committee, or he did not know how many cases require his recusal, which is his responsibility as CCA's general counsel. Another chief complaint against Puryear is that he only served as a judicial clerk, and during his time in active litigation as a trial lawyer has been very scant. He spent only 3 years working at a Nashville law firm, and one of the attorneys at that firm stated that Puryear was hired outright or right out of law school as a young lawyer and mainly assisted other attorneys. And according to federal court records, Puryear has been listed as counsel of record on 130 cases in the U.S. District of Tennessee during his legal career, which sounds impressive. However, an examination of each of those case dockets reveals 85 cases were dismissed by the court without service on the defendants. In essence, Puryear did nothing. 39 cases were handled by another law firm or attorney. Puryear was not directly involved. One case was answered by Puryear personally. He sent a letter saying the defendant had died. And then 5 cases included Puryear's personal involvement, all from 1994 to 98. And then one other chief complaint of Mr. Friedman against Puryear is that this is strictly a partisan political appointment. Puryear is a dedicated Republican supporter, having previously worked under Republican Senator Bill Frist and Fred Thompson. He was an advisor to Vice President Cheney during the 2000 debates. He has given at least $13,000 to federal and state Republican campaign committees since 2001. $3,000 to Bob Corker, $1,000 to Mitt Romney, $2,000 to President Bush for the 2003 primary. Puryear's employer, CCA, has been generous to Tennessee Senators Lamar Anderson and Bob Corker, too. And all of this is par for the course, since most federal appointments, including district court judges and U.S. attorneys, are political in nature, even though they like to say they're independent judiciary. Still, federal judges who are supposed to be impartial should not be as blatantly partisan as reflected by Mr. Puryear's record, irrespective of party. Political payback should not be the basis for a lifetime appointment to the federal bench. This goes for Democratic nominees too, and I second his opinion on that. A couple other things that have basically been laid forth by Mr. Freeman about Puryear is that he actively worked to hide damaging information about the company from the public, including governmental agencies that contract with the company.
Are you saying he hid a lot of information?
Yeah, in his advocacy as a attorney for CCA, yeah, that's what he's alleging here, and he lists a number of incidents at the Bay County, Florida jail in 2004, which resulted in a prisoner and nurse hostage being shot by a SWAT team member. It says CCA refused to release an after-action report related to the incident. And Mr. Puryear arranged to have a private law firm provide the report to protect CCA from liability, and stated that the report would never become public record. And notably, reports by Bay County officials and Florida state officials related to the same incident are public records. Yet they, through their legal trickery, sought to hide what happened in that incident. And then another kind of tricky thing they did, and this is, like I said, this is kind of like the United States version of Guantanamo's, these CCAs. In 2005, CCA's Quality Assurance Division was placed under the company's legal department so that internal quality assurance reports would not be subject to public records laws. And so this is another legal trick that was played to hide information from us, the unsuspecting public. And by designating such reports as attorney-client privilege, they could be kept secret for in-house use only.
Have we ever seen that done?
Yeah, I'm
All the
sure
time.
we've
DHS and the AG's office
yeah,
do that all the
they
time.
play those little games. And then a couple other little quick things that he puts in here about that. He in a questionnaire, it looks like submitted to the Senate Judiciary Committee, Mr. Puryear said he was a member of the Belle Meade Country Club. And the questionnaire asked Mr. Puryear to indicate whether any of the organizations he belongs to currently discriminate or formerly discriminated on the basis of race, sex, religion, or either through formal membership requirements or to the practical implementation of membership policies. And Mr. Puryear's response was, while I have no personal knowledge of any prior discriminatory policies by Belle Meade County Country Club, I can understand there were no African American members prior to 1994. And Alex Freeman goes on to state there is still only one member since 1994 that's African American to the Belle Meade Country Club. And just he says that Mr. Puryear maintains membership in a club that didn't admit its first black member until '94, and it almost is exclusively white, and reportedly it does not afford voting privileges to female members when such privileges are afforded to male members. Is troublesome for a federal judicial nominee, not just from the standpoint of racial and gender discrimination implications, but also in terms of Mr. Puryear's character and poor judgment in being a member of such a club. I think this is you guys should definitely check out this website. It's very interesting. I think it's excellent work by a citizen to try to bring to light some of the qualifications or lack thereof of a judicial nominee. I think that if the Senate members were this detail oriented, we'd probably have a better judiciary. But luckily we have people out there that are willing to go the extra mile and do all this research on their own, put together a website with documents all interlaced throughout the website to prove what they're saying, and to actually back it up and lay forth several different reasons why this guy shouldn't be nominated. So I just would like to point you again to againstpuryear.org. And there's a couple of numbers on that website you can call if you want to complain, or if you want to still support Puryear, you can actually call the people that are listed on the website, the ranking Senate members that are going to be basically voting on his nomination if it's done in time here before the next election. But that's my little tidbit of information on the judiciary and the justice system for this week. But
Sounds like money is buying his way into the judgeship.
yeah, well, I mean, it doesn't sound like experience has got him there. And they went on to say that well, the ABA voted him qualified, or well, they do that for a lot of the people that are going for judges or whatnot. I mean, they're really, when you look at how they do this or how they rate people, I mean, there's really no set standard on how they rate people. So, I mean, it really doesn't mean a whole lot. Now, if they sit there and they said, well, this guy, to get this rating, this guy would have had to sit on this many court cases. He would have had to acted as a trial lawyer in this many legal cases, and had done in this kind of case, this kind of case, this kind of case, and they had these sort of set standards, then of course those ratings would mean something. But when you sit there and you say, well, this guy's qualified or this guy's not qualified, and there's no standard, it really don't amount to a hill of beans. So that's my opinion on the ABA ratings. And I really think that this website actually does a more thorough job of examining this judges or this nominated potential judge qualification than the ABA can do with their standardless rating system.
Now, you alluded to the fact that he had been in business, which may, or at least should, disqualify him from taking over a judgeship, which uh, uh, could find him having to recuse himself every once in a while. Is there a time limit that you think that a person, or should he be forever barred because he works for Motorola or General Motors or something, and that connection could uh, diminish his ability to act in fairness? Should there be a 10-year period, a 20-year period? Should there be a 2-year period in which he is away from any direct business venture that would be contrary to his responsibility as a judge?
Well, I think, he wasn't actually in business for Correction Corporations of America. He was actually a general counsel. He was the head counsel for their large for-profit prison corporation. Um, and I think being in the same district where there's so many cases against Correction Corporation of America, I mean, it's just going to require him to recuse a lot of cases. I mean, they only have like a few district judges in any set district. So, I mean, who's going to handle all these hundreds of cases? I mean, the other judges? So, I think that when you have someone that's that close to the prison corporation or prison institution, they've made that much money. I mean, I really don't know if I could say that this guy would ever be fair to someone that would be in the justice system. I mean, I would say that the guy would have to have experience as a defense counsel first before I would even consider him to be a fair and impartial judge. Because I mean, I think you got to be able to weigh both sides. When you're just coming in on one side of the coin, and you've got so many cases that's going to come before you, and you only have that one view, then it's not going to make an impartial fellow. I mean, I think that the guy really needs to spend some years as a defense counsel as well if he's going to do anything related to confining or in matters confining people. I mean, it's just now if he worked for a corporation or owned a corporation or company or something like that, the amount of cases that would be necessarily going against one company or whatnot are going to be far and few between. But when he's representing an institution is that vast, 66 institutions across the country, and their headquarters are right there in the district, and hundreds of people are suing him. I mean, it's not a good scenario or situation. They might be paying him under the table for what everybody else knows. I mean, to basically turn his head. I mean, the guy's made millions and millions of dollars off of this company, and I'm sure he's definitely well affiliated with the people in the company, so as to make a reasonable question of whether or not this guy could be fair. I mean, it's just I wouldn't really trust it.
Okay.
Experience.
That's like the fox guarding the hen house. Almost.
Right.
Experience from 20 years of watching how attorneys do things. I have seen attorneys jump from one side to the other representing issues, and they win cases. They're pretty good at winning cases, but they'll flip-flop back and forth, and I came to the conclusion it depends on who's paying them.
Yeah.
We saw an attorney who used to work, as I remember, for the ACLU, and then won a case, then jumped into the Attorney General's office and winning cases right and left there, contrary to what he was doing before. So that tells me that it's the money that controls the Attorney General's office.
Okay. Well, thank you so much for those comments. And just a side note, not directly connected to the main core of your message today, was that of where they claim attorney-client privilege. And one extreme case of that is where I had a judge in deposition, um, uh, and the attorney for that judge was from the Attorney General's office. And she says, I'm not going to permit my client, who was a judge, to answer that question. And I said, would you tell me why? And she says, that's attorney-client privilege. And I said, ma'am, did you realize that the attorney-client privilege can only be raised by the client, not the attorney? Well, she said, I'm raising it on his behalf. So we have a rule that says that the attorney cannot raise the attorney-client privilege, but in this case, the attorney was raising the attorney-client privilege on behalf of the client. Well, that's stretching credulity a great deal, isn't it? To play games of that sort. Well, the judge spoke up. Well, he said, "I'll raise it myself then." So he raised based upon the recommendation of his great attorney from the Attorney General's office. He raised the case of attorney-client privilege.
It should have been called judge privilege.
Yeah, right.
That's what they should have termed it correctly.
Correct.
Because in actuality, it really didn't make a whole lot of sense.
No.
Because they're judges,
That's right.
they're going to make it make sense.
We've been looking over some articles that probably are in the director of legal solutions here in his department. But would you take a look at one that says about a brave judge that resists the feminist agenda? Don.
Okay, John. This article is written by Phyllis Schlafly. She's on Christian Radio. This is dated August 8th, 2008. A New Jersey judge recently confronted an issue that courts have been avoiding for years. Are restraining orders constitutional? Accused criminals have due process and many other constitutional rights, but the feminists have persuaded many judges to issue orders that restrain actions of non-criminals and punish them based on flimsy, unproven accusations. These restraining orders are issued without the due process requirement for criminal prosecutions, yet they carry the threat of a prison sentence for anyone who violates them. It makes it sound like it's not worthy of attention, really. But on the other side of the coin, if you go to prison for many years, I think it is worthy of attention. Mr. and Mrs. Crispo were divorced and rearing their children in the same household when they had a fight. Mrs. Crispo asked for a restraining order. Mr. Crispo was not charged with any crime, but the judge issued the restraining order, which banned him from his own house and thereby separated him from his kids. Without a hearing, that happened. Mr. Crispo made several good arguments that the New Jersey Prevention of Domestic Violence Act is unconstitutional. Judge Francis Swartz rejected most of those arguments, but he cited a long line of cases holding that clear and convincing evidence is required in order to take away fundamental rights such as a parent's right over the care and custody of his children. The feminists are in an uproar about Judge Schultz's decision and would like the New Jersey Supreme Court to reverse it. The feminists went to court to uphold a woman's right to kick a man out of his home based on a woman's unverified accusations. And John, that's sometimes based on the DHS whispering to the woman, if you want your
Correct.
kids back, kick
Yeah.
your husband out.
Right.
And so she's in a dilemma. What does she do? She loves her husband, she loves her kids, but she wants to keep her kids, so she kicks her husband out. Okay, this article goes on. Family courts are notorious for issuing restraining orders based on one woman's unsupported request. The New Jersey Law Journal reported that an instructor taught judges to be merciless to husbands and fathers, saying, throw him out on the street, give him the clothes on his back, and tell him, see you around. People have a better chance to prove their innocence in traffic court than when subjected to a restraining order. Well, I don't know. They're both low on the totem pole as far as defending yourself. Because you can't, in traffic court, you can't stand on the Iowa Code. You can't stand on the Supreme Court. Or not the Supreme Court. Supreme Court rulings and the Constitution. So it is with restraining order. You basically have no rights in this country, I guess. Too often, the order serves no legitimate purpose, but is just an easy way for one spouse to get revenge or the upper hand in a divorce or child custody dispute. Once a restraining order is issued, it becomes nearly impossible for a father to retain custody or even to see his own children. And eventually it leads to termination of parenting rights. Never to see your children again. And this article finishes, that is the result, even though the alleged domestic violence, which doesn't have to be physical or even proven, may never happen at all, did not involve the children at all. John?
Okay, thank you. Thank you so much for that article. I think what happened was we opened up with the last half of that at the beginning of the program and picked up this first part, but Phyllis Schlafly was the author of that, and she's looking very carefully at some of the misdeeds that are causing us time and time again to lose bits and pieces of our constitutional rights. And she happens to be a very outspoken individual and makes a lot of sense. I think it behooves us to listen to the things that she's saying and to attempt to equip our legislature with the kind of individuals who will go along with the Constitution rather than a legislative ordeal whereby we boot out fundamental rights of First Amendment rights, Second Amendment rights, Fourth Amendment rights, Fifth Amendment rights, Sixth Amendment rights to confront, Eighth Amendment rights against cruel and inhuman treatment. All kinds of rights can be diminished, and I looked at an article that looks at Fourth Amendment rights as if there are many ways in which law officers can very carefully knock your door down and walk into your house. But they have to be careful about it. Well, I'm not sure that when we developed the Fourth Amendment that we considered law officers carefully abiding by certain rules to enter your house. I thought it was that no-knock type of ventures were completely out of bounds, but they're finding new and better ways of handling that. Well, last week we told you we would give you a little bit of a hint as to how to block social workers in devastating your family. That knock at the door is an invitation for you to permit a social worker to enter your home. If you let the social worker cross your threshold, you have basically given up your Fourth Amendment rights. There is a quandary as to whether you should actually ever talk to the social worker in the first place. And what we've recommended is if you have a problem, ma'am or sir, sometimes there are some men who are social workers, although now it seems as though that department is being taken over by the women as well. It seems to be a good job for women. But anyhow, when you talk to that person at the door, him or her, tell that person that you want their concerns to be answered properly, and that would they put their concerns in writing with sufficient information that you can properly answer them in writing. That way you can talk to somebody else in the meantime and gather the information necessary to follow up on that. Well, once that paper is written, Don, you need to take that paper and to get a hearing, particularly if it's an adverse ruling. Would you give us a clue how you can get on the computer and address your need for an evidentiary hearing? Don?
Okay, John. We could show them
We lost you here.
show them the website here when it comes up in a moment here that you can go online.
It'll take a little while to write that down, won't it?
And when you go online, you open up, you can go into the appeals and open up the form where you can fill it out and send it directly into the DHS, and that automatically sets you up for an appeal if you disagree with some action by the DHS. Abuse reports also includes food stamps and child support, any denial that DHS has done to you. We'll put this up here, John, and that shows us the form that they'll be filling out your name and address, and go on down toward the bottom here, John. And if you need an interpreter, there's more and more need for that, that you check the box for that. Also, it asks for, I want a pre-hearing conference. I strongly recommend that. And you want to go for discovery. Just because you got one piece of paper in your hands saying that there's an abuse report written against you.
Can you submit this on the computer then?
This will be sent in online, correct?
Okay, online. You want to put up our telephone numbers, because we're coming close to the end of the program, and we'll talk to you about these issues another time in a little greater depth. These are numbers that may be useful to you in your battle with Department of Human Services and the Juvenile Court. We'll see you.